Welcome in, everybody, to today's webinar with the Colorado Fruit and Vegetable Growers Association Lunch and Learn webinar. What's new? H-2A and federal labor policy under Trump. What's new and what's next? I'm Adrian Card with Colorado State University Extension and board member of the Colorado Fruit and Vegetable Growers Association. I'll be your host for today's Lunch and Learn webinar. And this one is part of a spring series of labor webinars with CFVGA. And upcoming this Friday, we'll also have the CDLE wage law for Colorado agriculture, revisiting the 2021 ALRA, highly seasonal peak weeks, calculating overtime wages in the new 2025 enforcement wage law. And then next week, next Thursday, March the 26th, we'll have understanding and complying with overtime, understanding and complying with hand weeding variants with ALRA. If you haven't seen the registration from these for CFVGA, you're welcome to email me at adrian.card@colostate.edu. Today's webinar will explain key information regarding recent federal policy rules, priorities, and actions. CFVGA is a go-to resource for Colorado's fresh fruit and vegetable farmers. We connect Colorado growers with industry, government, academia, and consumers to strengthen and expand Colorado fresh fruit and vegetable production. Learn more at coloradoproduce.org and follow CFVGA on facebook.com/CFVGA. We've probably all attended webinars, but a little bit of housekeeping for a Zoom webinar if you haven't been in one in a while. Your portal for access is going to be a Q&A box that you should see in your webinar toolbar. And these questions will be answered after the presentation by our presenters. All questions will be visible to all of the attendees. You can ask anonymous questions, and you can also upvote particular questions if you want to raise our attention to those. If we have a lot, we need to prioritize which to answer. You're going to see two polls. We'll have an opening poll and then one that is at the end of the webinar, and neither are visible in the recording. The recording will be posted to the coloradoproduce.org labor page as on screen now. I want to introduce our two presenters, and I'm going to pass over to them. Our first presenter today is Tom Bortnyk, and Tom is a Senior Vice President and General Counsel from MasLabor, the nation's largest provider of H-2A and 2B services. He's nationally recognized as subject matter expert advising the company and its clients on H-2 regulatory compliance issues. And he's also the founder of the company's enterprise business unit, which offers services related to employment-based green cards and professional visas. Tom holds a BS in International Affairs from Florida State University and a JD from Washington and Lee University School of Law in Virginia. And our second presenter, Jason Resnick, has over 20 years of experience with Western Growers, serving as Senior Vice President and General Counsel, overseeing the organization's legal affairs. And member of the senior leadership team, he provides advice and counsel on various legal, business, and policy matters. Additionally, he founded and oversees Western Growers H-2A Services, a full-service H-2A agent operating exclusively for the Western Growers members. Jason frequently speaks at Allied Association events and contributes to magazine articles on H-2A, agricultural employment, and ag labor law issues. With that, if you could clap, you would be helping me welcome our two presenters, but we'll pass over now to Tom. Thank you, Tom. And Tom, you're muted. I muted you for some background noise, so sorry about that.
Noise. Well, hello everyone. Happy to be here. Appreciate the introduction and appreciate Jason being here as well to talk through all the crazy things happening in our industry. So what we decided early on is that we were going to divide and conquer. There's a lot of ground to cover, and I know we're kind of short on time. So I'm going to start off by talking about what's probably at the top of everyone's mind, which is the new wage methodology. And then I'll turn it over to Jason, and he's going to cover a lot of the other interesting policy developments that we've seen over the last year. So just for some context, just so we can understand kind of how we got here. Everybody probably, if you've been in the program long enough, you probably remember that the Biden administration disaggregated wages. So the Biden wage methodology really started looking at the idea of standard occupations versus non-standard occupations. And what they're really trying to do is target things like truck drivers and supervisors and things like that. So what the Biden rule did is effectively maintain the long-standing adverse effect wage rate methodology, but only for standard kind of traditional farm jobs, your general farm workers, your ag equipment operators, packing house workers, etc. For everything else, all those other jobs that you may use H-2A workers for, you would get assigned a non-standard occupational classification, and that wage would be governed by a different wage source. It would be governed by the OEWS, the Occupational Employment and Wage Statistics. Quite a mouthful, but it's a survey conducted by the Bureau of Labor Statistics, specifically on non-farm employers. And that was kind of the root of the controversy. So obviously what that did is it dramatically increased wage rates for things like truck drivers. We saw some other peculiarities that emerged from that rule. And so the industry mounted a pretty effective legal campaign to try to invalidate that Biden era rule. Now, there was a lot of cases. National Council of Agricultural Employers was involved in one. One that was very effective was brought by the Louisiana sugarcane industry. And this was specifically over sugarcane hauling and the truck drivers that would haul harvested sugarcane to the mills. They were able to secure an injunction and get a court to basically, strike down the rule only for Louisiana sugarcane growers. So very limited in scope. What happened then is that the Trump administration took office. So we had a change of administration. And when the incoming Trump administration looked at the situation, they decided to settle the case. And settlement in this instance means admitting that the Biden era rule was illegal, that they didn't have the authority to issue it, and that they would go ahead and vacate that rule entirely. So what that did for a very brief moment in time is basically change the methodology back to the status quo, back to what it was for the last many, many years. Now, subsequent to that settlement, there was another development, namely that the U.S. Department of Agriculture announced that it was terminating the Farm Labor Survey. So for those of you who you probably know this, the Farm Labor Survey served as the source of that AWR methodology. So that's where the wages came from. So if you eliminate the survey, you eliminate the underlying source of data, and therefore you have a wage methodology that has no statistical basis behind it. It's just basically a void in the law. So what's interesting is that it used that circumstance, the fact that there was no wage data anymore to support the existing wage methodology, and they used that to come out with a new methodology entirely, and they were able to do it as an interim final rule. So just to get a little bit lawyerly for a second, typically when you come out with a regulatory change, especially one of this magnitude, there's an opportunity for stakeholders to really weigh in on it. This was put out with immediate effect. So it's sort of like an emergency circumstance that allows them to jump right to the fun part, make it enforceable right away. So there was no sort of comment period or lead up to that rule being implemented. Now, if we get into the specifics as to what this rule does, it's obviously very complicated. I'm going to hit the high points because I know it's a lot of ground to cover. The Biden era rule bifurcated wages between standard and non-standard. That was also done here. The key difference is that it's not sort of a sudden death overtime situation where one duty can put you into a higher wage category. It's based on primary duties. What are the workers doing the majority of the work days, right? So that it's not one particular duty that might throw you off. If you have duties that are performed incidentally or on a secondary basis, that will not affect the wage. Now, the other thing that this rule did is it bifurcated wages according to skill level. So if you think about, instead of having one size fits all, the Trump administration has created a two-tiered system, skill level 1 for more entry-level jobs and skill level 2 for more experienced jobs. That's talking about the jobs themselves, not the experience of individual workers, right? And skill level looks at whether there's experience requirements, whether there's educational requirements, whether there's any kind of specialized training involved. Principally, though, it's looking to the ONET database. That's kind of the source of all that information. And it's looking to what is normal for that occupation according to this ONET database that's, again, based on survey data conducted by the Bureau of Labor Statistics. And of course, as you might imagine, skill level 1 wages are considerably lower than skill level 2. And so there is sort of an incentive. You pay less money if the job itself has a lower set of requirements. And just to kind of illustrate the point here, this is kind of the holistic evaluation that they're looking at. Skill level 1 would be sort of no specialized education, but you may have some modest work experience requirement, less than what is normally allowed. Skill level 2, you might have an education requirement. You might have certain certifications that are required. And you probably require experience that is sort of at or above that normal threshold. Now, there's a curveball to that, which is until very recently, in fact, this happened in the last couple of weeks, there was only 2 standard H-2A occupations that were considered job zone 2, meaning for the vast majority of H-2A employers, the minute you list 3 months of experience, you're skill level 2. So 3 months had been sort of the gold standard for experience requirements for decades. And this forced a lot of employers, if they want that skill level 1, to drop that experience to 2 months, right? Based on what the ONET profile said for that occupation. Last month, ONET actually updated the range for every single standard H-2A occupation, and they raised that allowable experience range. So in theory, this should allow skill level 1 jobs to have 3 months experience before, without getting bumped up to that higher wage level. That is still playing out. We've seen some early success with it, but we've also seen the Department of Labor fight back on it a little bit. And so that situation will certainly continue to evolve. Now, the other last thing I'll mention here before I show some Colorado specific information is this idea of a compensation adjustment. So probably the most radical provision that's in this new rule is the fact that there is a downward compensation adjustment of the adverse effect wage rate for foreign workers only. Meaning H-2A workers, you pay them at a lower effective wage rate than you would pay U.S. workers doing that same job. Now, the rationale behind that is that most H-2A workers are eligible for free housing, whereas most U.S. workers doing that job are not entitled to free housing. So it's sort of this material non-wage benefit that H-2A workers enjoy for the most part. And so DOL calculated the relative value of that benefit and determined that, on a state-by-state basis, what the dollar per hour equals. And that is then subtracted from the base rate that is paid to U.S. workers. So it's not a deduction, it's not a credit, it's a lower effective wage rate based on the fact that they are foreign workers, regardless of whether they live in the housing. And here's some Colorado information. Obviously, there's an obligation to pay the highest of. So I know there are certain localities that do have, a higher minimum wage. If that is the highest effective wage, that becomes the governing wage for your H-2A workers. I will note that in this particular case, under the old AWR methodology, everyone would have been paid $17.84 per hour. And that's actually right at the skill level 2 rate for H-2A workers. So if you are, at that skill level 1, in the case of U.S. workers, it would be $16.28 per hour, which is less than the old wage methodology. And for H-2A workers, the AWR is actually lower than state minimum wage, which means you would have to at least pay minimum wage to those H-2A workers. So it's really only a wage increase if you happen to be a U.S. worker at that skill level 2 level, relative to where it was under the old AWR methodology. So that's basically the lay of the land. Situation will certainly continue to evolve, but happy to take questions after Jason's presentation and get into the weeds on it.
Jason, you're muted.
Can you see the screen?
Yes.
All right. Well, good morning, everybody. And really appreciate having the opportunity to meet with you today and co-present with my good friend Tom. And so he covered really the big earthquake change that occurred over the past several months, the change to the A word. But when you think about the Trump administration and their priorities, immigration enforcement seems to be the thing that really takes over the dialogue and concern. It's the thing that I get the most questions about. Are our workers going to be deported? Are H-2A workers going to get caught up in all of the deportation that we're hearing about? And so we really have to distinguish between the rhetoric that's come out of the administration. We're talking about, some parts of the administration saying we are going to deport everybody. We're going to have mass deportations. We've seen the fallout in Minnesota, Minneapolis, and Los Angeles, and some other states, typically blue states, typically blue cities, but we're not seeing mass deportations or farm raids. So we've heard the administration say things like, we're going to go after the worst of the criminals. We're going to protect farmers and farm workers who are not violating other laws. So a couple of notes. Brooke Rollins, Ag Secretary, said recently in a statement that the administration was enacting, quote, real reforms to ease regulatory burdens and lower labor costs. I think that speaks to the IFR that Tom just spoke to as an example of that, and there's some others I'll speak to shortly. And President Trump himself said the farm economy is in a difficult situation, and the president's utilizing all tools available to ensure farmers have what they need to be successful. However, when you survey farmers and farm workers, we're seeing very little on-farm activity, so virtually no raids, but more than 14% in a California Farm Bureau and Michigan State University survey said that raids and general anxiety surrounding enhanced immigration enforcement have caused worker shortages. So even though we're not seeing raids, we are seeing some enforcement activity agents in rural areas, and their mere appearance is causing farm workers to avoid going to work for fear of being picked up on a rural road on their way to and from work. So that has had some real business implications. And then beyond that, you have workers who are experiencing real fear and confusion, and that has real effects. But again, we're not seeing farm raids. We are seeing that the real risk is your Form I-9 compliance. So it's just a reminder to always ensure that your Form I-9s are in good order. That's the biggest risk, because the liability or exposure for not having I-9s in good order can be quite sizable. And you could see a couple of examples on this screen where a Washington apple orchard paid $2.25 million fine for immigration employment verification violations. Another $1 million was paid in a civil settlement by an Oklahoma-based agribusiness. So even though we're not seeing a lot of raids or notices of inspection or Form I-9 audits, they do happen, and the implications are quite serious for those who are not in good order. There is a risk, however, that H-2A workers can get caught up in immigration enforcement activity. And you might ask, well, how can this happen? If someone's here on a valid H-2A visa, how can they be detained, deported? What happens? And generally, an H-2A visa holder who has their passport and visa I-94 documentation on their body, or at least photographs on their phone of their documents that are valid and not expired, generally will be just fine. But you get into a situation, and we've seen this a couple of times now, where H-2A workers were on one contract and then they were transferred to another contract with the same employer. And there's a time lag between the time that first I-94 document expires and the time where they get a new I-94. But it's important to note that when the employer or their agent on behalf of the employer timely files that extension, so that's the I-129 petition amending and extending that worker's stay, as long as that extension is timely filed and is not frivolous, it provides essentially 240 days of immunity for that worker to be able to stay in the country and get the new extension approval document. But it's that interim period where if a enforcement officer receives looks at the documentation and all they see is an expired I-94, and they're not aware that a timely extension has been filed, they might, as has happened in a couple of cases now, say, we're going to detain you, arrest you, put you into the immigration jails or detention facilities, or you can agree to self-deport today. Sign this document, we'll take you across the border, give you a little bit of money, and you can always come back. It's not the same as a deportation order. And oftentimes, because the implications of being deported are so dire, workers will take that option. So just a reminder here to workers, especially in this situation, to maintain their passport, visa copies to show proof of identity. The expired I-94 shows that they were legally entered the country. That receipt notice is that golden ticket. It's the proof of the pending extension, which starts that 240-day clock. And we suggest an employment letter, a letter on employer's letterhead saying that this individual is here on an H-2A visa and here are the circumstances. So that's something that the worker can show very quickly and the officer can understand it. In under a minute, they'll be in good standing, or should be. Other big changes. It happened last fall that the DOL said, hey, we're going to change to a new way to collect fees. We're not going to collect paper checks anymore. We're going to have an online portal. But until that online portal is up and running, we are going to cease collecting payments. That's a nice break for H-2A employers because that DOL certification can range from $100 to $1,000 depending on the number of workers. And they are not going to retroactively issue invoices for those who have been issued labor certifications after September 2nd. So from September 2nd until now and for the foreseeable future until future notice, employers can get a break on those DOL certification fees. The Office of Foreign Labor Certification will put a notice in the Federal Register when they're ready to resume collecting fees, and that portal is up and running. But until further notice, you do get a break. The other big change, and I consider this one pretty significant, is the change of policy regarding staggered crossings. So back in 2011, DOL said in a FAQ document that we believe that all workers under a labor certification should be brought in at the beginning of the contract, at the start date. And for those employers who prefer to have some portion of their workers come in at that start date and then later come in as they approach peak season or have later increased need, well, for those employers, they really should file a second or in some cases a third application for H-2A workers. Well, all that does is create more opportunities for cost, expense, and time delays because you're filing multiple applications. Each application has more costs, whether you're using an agent or an attorney, more costs with DOL, more costs with USCIS, and so on. That really created a disincentive for a number of farmers to not want to use the H-2A program. It just made it unworkable for some because of their no staggering policy. Well, this was changed by the Trump administration pretty early on, and it comes out of, again, the secretary saying we want to have real reforms that are going to ease regulatory burdens and lower costs. This is an example of that. So what does that mean? That means that you can, as an employer, have your start date and stop date, and you can bring in workers, some number at the beginning of the contract and some number of your choice later in the contract. But it is recommended and expected that you're going to disclose your staggering schedule. And we like to put in language in our applications that staggered schedule is anticipated, but may be subject to change depending on consular appointments and other factors outside of our control. And also, you can't stagger past the 50% mark because that would be seen as somehow going against the interests of U.S. and domestic workers and discriminating against them in some way. So the rule as it's been articulated by OFLC is you can stagger, just tell us what your plan is and don't go past the 50% mark. So obviously a great benefit for crop timing and labor needs, and just make sure you document what you're doing and communicating what you're doing on the staggering plan. Now, another big change, USCIS now has an electronic filing system, and also they allow a change in the sequencing of when you can file your Form I-129. So the old way, you had to get your DOL certification in hand before you could file your I-129 petition for non-immigrant visas, and then you wait and then you get your approval. Well, under the new policy that came into effect in October, DOL will start the process. DOL will issue a notice of acceptance before the certification is issued. And as soon as you have that notice of acceptance in hand, you can file your Form I-129 with USCIS. And that gets the ball rolling with USCIS, which in theory should mean that you're going to get your USCIS approval sooner than you might otherwise. So again, concurrent filing is now permitted using the new I-129 H-2A form. That's the form that's limited to their online portal. That form can only be used through the USCIS online portal. It cannot be used in paper filings. Paper filings still use the old I-129 petition. And then it's also important to note that you have to have a USCIS online account in order to file electronically. So benefits are great in that you get an immediate receipt notice as soon as you file that USCIS petition online. You don't typically have to wait for an email from USCIS. Earlier or easier case tracking through USCIS. Probably reduce risk of rejected filings due to clerical errors. But again, you have to have that USCIS account. Not everybody has transitioned to doing that. The employer also has to have a USCIS account that is tied into their agents or attorneys' account. So there's some administrative work that has to be done on the front end. And then also, the online portal has some filing constraints about the size of the document that can be submitted, and if there's too many megabytes in the documents, it might be rejected. So you want to try to reduce the file size in Adobe Acrobat if you can, and try to not hit those file size constraints. Despite this great change with the electronic filing system, which should make things go faster, I think Tom would agree, and anyone filing applications, it has been a rocky road. In some cases, we're getting USCIS approvals very quickly, just within a few days. Other times, for no reason, the same application could be submitted, or same petition could be submitted, and it could take weeks. In some cases, the petition just goes into a black hole and there's no receipt. There just seems to vanish. But that's happening less and less, I believe. But we are seeing some really significant delays out of USCIS for really no really understandable reason, except either that they are overworked, overwhelmed, or not really handling the new online filing system very well. They just seem to not have their ducks in a row quite yet. So obviously when this happens, you get issues with your start date. You might not get your workers when you need them. So you just need to file as early as possible, build in some slack so that you can, on the front end, make sure that you file as early as possible, which is 75 days before your start date, and then you can build in some slack to plan for some of these delays. How are we doing on time, Adrian? I want to make sure I don't over.
We've got about 1 to 2 minutes left.
Okay, so I'm just going to hit this really fast because this is only impacts employers who employ H-2A drivers. And there have been some significant changes to H-2A drivers, specifically with regard to non-domiciled commercial driver's license. Non-domiciled means they live in another country. And so those non-domiciled CDLs only apply now to a few visa categories. One of them happens to be H-2A, so that's good. And then drivers have to present certain documents, including their passport and an approved Form I-94. Used to be they could submit just their employment authorization document and get approved. There's more of a focus on safety requirements, and then they have shortened the validity period for that CDL. Now it expires on the earlier of the I-94 admit until date, or 1 year, whichever's sooner, and there's no grace period or practical renewal flexibility. So when it comes to your Mexican drivers, there is still reciprocity with Mexico and Canada. U.S. still recognizes Mexican CDL standards under these reciprocity agreements, but the issuance of these non-domiciled, the U.S.-based license is now restricted. So what that's doing at the consulate, there is an impact. First, speaking more broadly, interview waivers are still a thing. So H-2A workers who've worked in the last 12 months can get an interview waiver. First-time applicants are going to be interviewed. And this just kind of gives a overview of some of the issues that we're seeing in the consulate processing, one of which is administrative holds. Administrative processing holds are not uncommon, but we're seeing more of them. Typically, it's due to incomplete or inconsistent documentation with their DS-160. But the other big change is that farm labor contractors are listing the growers that they're working with. The consulates are calling the growers to say, hey, are you expecting H-2A workers? And some office admin answers the phone and says, I don't know anything about that. And that causes delays. So there needs to be good coordination between FLCs and their growers to expect their calls. There's always, the random visa printing issues, which is still a problem from time to time. So we are seeing more delays at the consulate. And then when we talk about specifically the drivers, or those with driving duties are getting more scrutiny. Specifically, they have to now bring a copy of their police report, copies of all their CDLs, and a copy of their Mexican driving record, and a police report. And they also have to demonstrate English proficiency. They are being tested on English proficiency at the consulates. And this is being required not just for CDL drivers, but really any H-2A driver who's driving on the road is being asked for these documents and being asked these questions. So I will pause there, Adrian, and we can take questions.
Sounds great, guys. I want to, as we go into the questions here, I forgot to do this. I wanted just to give you guys a poll. We can see some of our audience characteristics today. So we're going to do this simultaneously. You guys answer the question on screen, the starting poll, and we'll field a question first. The first one, for audits regarding I-9 compliance, how many years into the past will they go?
Well, I would say it's not really a fixed look back period. You always have to retain copies of the I-9 for your existing workforce, so everyone who currently works for you. After that, when they stop working for you, there is a retention period of 3 years from the date of hire or 1 year after the employment ends, whichever is later. So that would be the retention period. You're always going to have to maintain copies of the I-9 for everybody currently on staff and then former employees up to that retention period time frame, depending on when they started and ended work.
And in response to the poll question, sharing those now for you, we have 64% of our respondents have H-2A workers and 7% considering for the future. And various amounts up to 40 more, 70% of them, their H-2A accounts for more than 60% of their workforce. Lots of H-2A use here. The second question, and I think I'm interpreting this correctly, is do H-2A workers in the United States receiving overtime, or those overtime wages subject to U.S. income tax? You guys see the same question?
Yeah, I'll take a stab at that. So under the One Big Beautiful Bill Act, as they called it, there is an exemption for overtime, tax on overtime, tax on tips, some great deductions there. But that only applies in terms of the overtime to overtime paid under the Fair Labor Standards Act. Under the Fair Labor Standards Act, agricultural workers cannot and do not get overtime. It's only under the state laws that they can get overtime, like in Colorado and California and others. And those state law overtime requirements do not allow the employee to get a deduction for overtime for state required overtime.
Okay, great. So while we're going into the final question in the Q&A, and encourage all of you, now's the chance with our experts in the webinar, type in your questions. Want to know what you learned today? Here is your second poll, educational outcomes. Did you learn something new? Will you use what you learned? This question asks, will DOL fees have to be paid back in the future?
According to DOL, the answer is no. That the certification fees that they've essentially waived are not going to require back payment until they get their act together and bring back the fees. So according to Brian Pasternak, who's the administrator of OFLC, there's not a definite timeline for when those fees are going to resume. So for the time being, it's certification fee free.
But if you did receive an invoice, prior to the change in policy, but don't think that you can get away with not paying that invoice. Any certification fees that were invoiced, you have to pay. But any certifications that came without an invoice, you got free parking. You got free parking.
Great. The questions are rolling in. We have workers that have indicated they will not be returning this year. They're green card holders and or H-2A due to fear of immigration enforcement. Anything we can do or say that can help calm them?
I mean, I would simply say that this administration is focused on deporting those who are illegally in the country. But if you come in on an H-2A visa, you are coming in legally, and the country fully supports that, and they should have nothing to worry about as long as they were truthful at the consulate when if they were asked questions about their history in the United States and they were issued a visa, they should have nothing to worry about.
Great. Our H-2A workers.
Yeah, and I would add that, on that last question, I would just add that it's easy to get caught up in kind of the media headlines of everything and feel like it's happening kind of nationwide. There's a mass crackdown. I would say that has not been our lived experience. We've had some workers get detained and questioned here and there, but by and large, I think in 100% of the cases, they were released after a very, very short period once their work status was confirmed. So we haven't seen any kind of widespread issues with H-2A workers in particular.
We have great educational outcomes. I'll show those while we're going into the next question. Are H-2A workers eligible for earned income credit payments?
I don't answer tax questions.
You do CPA.
I think the answer is no, but I would recommend talking to a tax professional on that one.
I think that's right.
Okay. Our H-2A, let's see, done there. Will growers know when fees have resumed?
How will growers know? Well, certainly Western Growers and MasLabor and CFVGA will notify their members and clients of any changes as soon as they're announced.
Our final question is, how do we best notify DOL of our staggered entry plans?
Well, we just put it right in the application. We say, our intent, we intend to bring in the workers, X number of workers on this date, Y number on this date, Z number on the following date. And there's a place in the application to put that information. It's nothing more required than that. And then again, we just always put a disclaimer that these are our best estimates of the schedule, which is subject to change. And as long as you're transparent, you shouldn't run into any issues.
Great. Any parting thoughts, Jason, Tom, as we conclude today's webinar?
Well, I will just add that Tom did a great job going over that interim final rule. That rule has been challenged by the United Farm Workers, and there is a motion for a preliminary injunction that is being heard today in Fresno, California. So we don't have any new information to report, no breaking news this morning, but sometime after today, we should at least have some tea leaves that could be read on where the judge might be leaning, but we wouldn't expect a ruling on that preliminary injunction motion for weeks or potentially months. And that can all be mooted, that is rendered to be a nullity by a notice of final rulemaking, which would displace the interim final rule with a new final rule and render the interim final rule challenge moot. And maybe we just start all over again with the legal challenges.
Great. And I see Tom answered a question in the chat for you guys. If you want to look at that related to three-quarter wage not met due to wildfire drought impact, does it qualify? Tom has that answered for you. Thank you guys so much for bringing your expertise to Colorado from Virginia and from California remotely. We really appreciate all your work with Colorado Fruit and Vegetable Growers Association and with CSU Extension, and wish you both a wonderful day. And all of our attendees, look for this recording at the CFEGA Labor website. And if you do need links to additional webinars or whatnot, feel free to email me. Thanks, everyone, and have a great day.
Thanks, everyone.
Thank you.
Thank you, guys.